DUID crimes in Wagoner County involve accusations that a person drove, operated, or was in actual physical control of a vehicle while under the influence of drugs, medication, marijuana, or another intoxicating substance. These cases can be more complex than alcohol DUI cases because a drug test does not always show when a substance was used, whether the person was impaired while driving, or whether the accused was actually unsafe behind the wheel. Because the consequences can be serious, the defense should focus on the traffic stop, officer observations, field sobriety tests, drug testing, medical explanations, and whether the state can prove impairment beyond a reasonable doubt. What is DUID in Oklahoma? DUID means driving under the influence of drugs or an intoxicating substance. Oklahoma law can apply to illegal drugs, prescription medication, medical marijuana, over-the-counter medication, or a combination of substances. A person may be accused of DUID even if the substance was legally possessed or lawfully prescribed. The state must prove the specific legal elements of the charge. In many DUID cases, the central question is not simply whether a substance was present, but whether the accused was under the influence in a way that affected safe driving. Medical marijuana DUID cases. Medical marijuana creates frequent DUID issues in Oklahoma. A person may have a valid medical marijuana card and still be accused of DUID if law enforcement claims the person drove while impaired. A medical card does not give anyone permission to drive while under the influence. These cases can be difficult because marijuana may remain detectable after the period of active impairment has passed. The defense may challenge whether the test result proves impairment at the time of driving, whether the officer observed actual signs of unsafe driving, and whether the state can connect the test result to the driver's condition at the time of the stop. Prescription medication DUID cases. A DUID case may also involve prescription medication. Many people take medication exactly as prescribed and still find themselves accused of impaired driving. These cases may involve pain medication, anxiety medication, sleep medication, muscle relaxers, antidepressants, seizure medication, or other lawful prescriptions. A valid prescription is not always a complete defense, but it can be important evidence. The defense may examine dosage, timing, tolerance, side effects, warnings, interactions with other medications, and whether the accused actually showed signs of impairment. Actual physical control. A person does not always have to be driving down the road to face a DUID-related charge. Oklahoma law also includes actual physical control. This issue may arise when a person is found in or near a vehicle while parked, asleep, stopped, or sitting in the driver's seat. Actual physical control cases depend heavily on the facts. The defense may examine whether the vehicle was running, where the keys were located, whether the person intended to drive, whether the vehicle was operable, whether the person was safely parked, and whether the person had taken steps to avoid driving. Repeat DUID offenses. Repeat DUID crimes can create more serious punishment. Oklahoma law includes enhancement provisions for later DUI or DUID offenses within the applicable look-back period. A prior conviction, deferred judgment, or qualifying municipal conviction may affect whether a later offense is treated as a felony. Because prior cases can change the seriousness of the charge, the defense should carefully review the older case, date of completion, type of disposition, and whether the state can properly use it for enhancement. Challenging the traffic stop. Many DUID cases begin with a traffic stop. The officer may claim the driver crossed a lane line, failed to signal, drove too slowly, or otherwise appeared suspicious. If the officer did not have a lawful basis for the stop, the defense may ask the court to suppress evidence obtained afterward. Dash camera video, body camera video, dispatch records, officer reports, and witness statements may help determine whether the stop was justified. If the stop was unlawful, the state's case may be significantly weakened. Challenging field sobriety tests. Field sobriety tests are common in DUID investigations, but they are not perfect. Tests such as the walk and turn, one-leg stand, alphabet test, counting test, and other roadside exercises can be affected by many non-drug-related factors. Medical conditions, injuries, fatigue, nervousness, Poor balance, bad weather, uneven pavement, footwear, age, and confusing instructions can all affect performance. A person may look impaired to an officer for reasons unrelated to drugs or alcohol. Challenging drug recognition evidence. Some DUID crimes and investigations involve a drug recognition evaluation. An officer may look at pupil size, pulse rate, coordination, muscle tone, statements, divided attention, and other signs. The officer may then claim the person was under the influence of a certain category of drugs. This evidence is challengeable. The defense may question the officer's training, whether the evaluation was performed correctly, whether medical issues explain the observations, whether the officer assumed impairment too quickly, and whether the conclusion is supported by reliable evidence. Challenging blood or urine testing. DUID cases may involve blood or urine testing. The defense may review whether the sample was lawfully obtained, whether consent was valid, whether a warrant was required, whether the chain of custody was preserved, whether the lab followed proper procedures, and whether the result actually proves impairment. A test result may show that a substance was present. That does not always answer when the substance was used, how much active impairment existed, or whether the driver was incapable of safely operating the vehicle at the time of driving. Lack of impairment. One of the most important defenses is lack of impairment. The state may have evidence of drug use or medication use but still fail to prove the person was impaired. Normal driving, clear speech, steady movement, polite cooperation, correct answers, and lack of unsafe conduct may support the defense. Video evidence can be especially helpful. Body camera and dash camera footage may show that the accused did not appear as impaired as the officer claimed. Illegal search and seizure. DUID crimes can involve constitutional issues. The defense may challenge an unlawful stop, illegal detention, improper arrest, invalid consent, unlawful search, involuntary statements, or improper testing procedures. If evidence was obtained unlawfully, the court may suppress it. Suppression can change the entire case because the prosecution may lose the test result, observations, statements, or other key evidence. If you have been arrested for DUID in Wagoner County, speak with a criminal defense attorney as soon as possible.